2, 1, start. She was involved in instigating the local population in certain Muslim dominated areas in Delhi to protest against the Citizenship Amendment Act 2019, which was passed by the Parliament, and the exercise undertaken by the central government for creating a national register of citizens. She tried to incite feelings of persecution. Council submits that the state has not cited even a single statement of any actual victim of the alleged violence, since such victim would disprove the appellant's presence during the riots and violence. Even copies of the CDRs and video footage are not being provided to the appellant to prevent her from showing that she was not present. It is accordingly the appellant's submission that the effort of the state is to embroil the appellant in events with which she had nothing to do. The principal allegation against the appellant is that she was engaged in a conspiracy to plan riots and destabilize the government. One of the principal accused advised the persons present to escalate their planned blockade of roads and said that giving inciting speeches would not work. More specifically, it is the state's allegation that the appellant was amongst the leaders who organized protests at a site described as Jafrabad, Delhi. Appellant engaged in distributing packets of chili powder to women protesters with the purpose of attacking police and military with it, and asked women and youngsters to stock the chili powder, empty bottles, firearms, petrol bombs, acid, and stones to be used when the occasion arises. The appellant's name is also sought to be included in the commission of the actual riots that occurred in northeast Delhi. Without the slightest hesitation, we may say that the special court's view does not imply that the court need not apply its own mind to form its own judicial view. Independent review of the evidence gathered may have been undertaken by an independent authority, and the central government may have accorded sanction for prosecution for offences. It is seen that the appellant's name appears along with that of several other co conspirators. The state cannot confuse the issues. We are constrained to express that in the mind of the state, the line between the rights guaranteed by Constitution to protest and terrorist activity seems to be getting somewhat blurred. If this mindset gains traction, it would be a sad day for democracy. In our considered opinion, keeping in view the background, profile, and position of the appellant, there is no reasonable basis to suspect, nor do we entertain any reasonable apprehension that the appellant will either flee from justice, or that she will tamper with evidence, or that she will intimidate witnesses or attempt to frustrate trial. The order passed by additional sessions judge is illegal, and it has not been passed after perusing the evidence recorded by the trial court. It has been passed in a routine manner on the basis of the application moved by the applicant, whereas in the application, even the material substance of the evidence recorded by the trial court constituting the offense was not containing. It is also surprising that the application has been allowed only because it was not objected from the defense side. It shows that the trial court has passed the order without going through the evidence and without applying his judicial mind. It is further submitted by counsel for the applicant that in the present case, recalling of the witnesses is not necessarily required because the charge against them has already been framed. It has come in evidence that the second accused was armed with pistol and deadly weapons. The other two co-accused were not armed with deadly weapons. In reply of the above contention, it is submitted by AGA that trial court has not committed any error in passing the orders. Since the defense was not having any objection of adding charge under section 147 IPC, there was no need to peruse the evidence adduced by the prosecution for this purpose. Trial court has not committed any error in adding charge under section 147 IPC, and it has also not committed any error in recalling the two witnesses for their cross examination for this purpose. The charge under section 147 IPC has been added in exercise of power conferred under section 216 CRPC. Since courts often tend to fall into this error, it is extremely important to bear in mind the words of the Honorable Supreme Court that grant of bail cannot be thwarted merely by asserting that an offence is grave, since the gravity of the offence can only beget the length of the sentence which may be awarded upon conclusion of the trial. Stop. U123.